Welcome back to the Closing Advantage Strategic Insights for Title Agents. Real property, real people, real stories, real consequences. I am your host, Bill O'Connell. Today we're going to talk about the ALTA owner's policy. The reason is because before we can get to claims, you got to have a basic understanding of what's in the policy. So the idea of teaching you about claims is to show you how the policy works, but you need a foundation to start. So today we're going to talk about the basics of the ALTA owner's policy. The policy forms the basis of pretty much everything you and I do every day. So it's important that you know what's in it. When you get questions about the policy and why the purchaser needs title insurance, it's helpful to know what's in it. Now, the American Land Title Association recommends that we keep it simple when explaining the value of title insurance. Say something like, as long as you own your home, owner's title insurance protects your property rights. It's a one-time purchase that protects your property rights for as long as you or your heirs own your home. And that's a good start. Start very high, go down low. But what happens when the consumer demands more? You guys have all had the engineer who needs to know the details? So are you prepared to give examples of the kinds of matters covered by the policy? Do you know what's in the policy? Have you ever read the policy? I don't blame you if you haven't. I once met a guy, an underwriter who I respected, who's now since retired, who told me one time he'd been in the business for 10 years and never read the policy. Why is that? Because it's a hard read. It's only 6 to 10 pages, depending on the type size and the format, but its language is precise. It contains a lot of defined terms and can be a challenging read if you don't have the foundation to decipher the meaning packed into each phrase. But don't let all that deter you. Every journey begins with the first step. So today, we're going to talk about what's in the policy. Now, basically, the policy contains covered risks, also known as the insuring provisions, the duty to defend, exclusions, conditions, Schedule A and Schedule B. That's it. Those are the parts of the policy. So we're going to go through each one of those briefly. Look, I could spend hours on the policy, but you might say, Bill, that's not fun. We're not having fun anymore. And so I'm going to try to keep it simple for you. You need to just have the basic understanding. And after you get the basic understanding, you can delve deeper and to try to decipher more of it. But for now, let's start with the insuring provisions. So the policy starts out with subject to the exclusions from coverage, the exceptions from coverage contained in Schedule B, and the condition. The XYZ title insurance company insures as of the date of policy and to the extent stated in covered risks 9 and 10. We'll get to that later after the policy, so basically post-policy stuff, against loss or damage not exceeding the amount of insurance sustained or incurred by the insured by reason of. And now we get to the covered matters. By the way, you should always keep a copy of the policy on your desk. I wasn't kidding when I said the basis of pretty much everything we do is contained in this. Most of the answers are in here. If you want to know why we do something, know the policy, okay? Because it's important. Okay, so to me, the policy has 10 covered risks. Now, in the 1992 version, it contained 4 covered risks. I call those the big 4. Now, in 2006, we expanded it to include 10, but pretty much those things were already included. It was just stated a different way. Sometimes it was in an exclusion, and then we said unless. But we decided to move it to the insuring provisions and we gave examples of things that are covered in covered risk number 2, which we never did before. So the idea was to try to help people understand what's in it, because as a title professional, we know when something doesn't look right, but the consumer doesn't always know that. So what are the big 4? Title being vested other than as stated in Schedule A. Now, Schedule A, we'll skip to that right now because that's instead of going at the end. Schedule A tells us what interest we have insured. Is it an easement? Is it fee simple? Is it something else? On what land? Land is a defined term in the policy. As you'll find in the conditions, when you see a capitalized word in the middle of a sentence, that tells you that it's a defined term in the policy. So on what land? Land is the land that is described in Schedule A. It's usually attached as an attachment because it could be long, or if it's a lot in a block in a subdivision, it could be right in there on the first page of Schedule A. Okay, in what amount of insurance? Also a defined term. On what date? Date of policy defined. That's basically the date of closing or the date of recording of the insured instrument, whichever is later. And for whose benefit, i.e., who's the insured. Okay, so that's number one. Title being vested other than is stated in Schedule A. Now, covered risk number two, any defect, lien, or encumbrance on title. That's what the policy used to stop right there. In 1992 and 2006, we added a bunch of stuff that was included in that statement, but now it's more readily available for all to see. Okay, so covered risk 2 includes, but is not limited to, insurance against loss from. Okay, then the policy goes in and it lists a whole bunch of stuff. We're not going to cover every one of them today, okay, but we'll go over a few. So the first one is a defect in title caused by, and this is my language, among other things, because I'm not going to go through every one of them, forgery, fraud, undue influence, duress, incompetency, incapacity, or impersonation. Okay, we want to know who we're dealing with, and they trusting that we know who they are. So it's important that we verify who's who. Number two, the failure of a person or entity to have authorized a transfer or conveyance. You want to know why we are so insistent on that we get the governing documents for all the entities that we deal with? It's because we need to know that the person who is signing on behalf of the entity has the authority to do so, that the entity is properly formed, and we can't do that if we don't see the governing documents. Okay. The last one I'm going to go over is a document affecting the title not properly authorized, created, executed, witnessed, sealed, acknowledged, notarized, including by remote online notarization, or delivered. Okay, so more of the same. We need to know that it's properly executed. It's important. And then, of course, we cover a lien of real estate taxes due or payable but unpaid. Taxes have priority over everything, people. So we need to make sure they're paid through the date of the policy. Okay, number three of the big four, unmarketable title. Now, what does that mean? Well, I know it when I see it. Okay, but generally what the courts have said is that no title is perfect. Okay, and a title becomes unmarketable if a person who is ready, willing, and able to purchase or lend on the property has a reasonable basis to be concerned. So that's, I could give you examples, which I'll do in claims, but for the most part, it's, look, if I'm not willing to put my money on the line because I'm worried about something that's happened in the past with respect to the title to the property, well, that makes it unmarketable. So we're always cognizant of that. Okay, and number four, no right of access to and from the land. We ensure a legal right of access to and from the land under the basic owner's policy, the standard owner's policy, the ALTA owner's policy, several names for the same thing. We ensure that you have a right of access based on a legal right. Now, what does that mean? Well, does the property front on a public road? If it does, then we have a legal right of access, unless there's something in the record that says you can't access the property by this public road. And that happens from time to time. So we got to make sure that we have a right of access, either by an easement or because the property's on a public road that we get to use. Okay, those are your covered risks. Now, let's get to the duty to defend. So immediately after the covered risks, the policy says, in essence, subject to the conditions, we will also pay the costs, attorney's fees, and expenses incurred in defense of any matter insured against by the policy. And the payment of these costs and fees do not reduce the amount of insurance. So that's on top of the amount of insurance. If a claim comes in and we defend it and we make title as insured and it costs us $100,000 to do it, and you had a policy for in the amount of 500,000, guess what? When it's all said and done, your policy still got a $500,000 worth of coverage on it. Okay, so this is on top of the amount of insurance. And look, if you've ever spoken to a lawyer, costs add up fast. There's the old joke. You've all heard the old joke. Talk is cheap until you talk to a lawyer. Yeah, so we're always cognizant of having to defend a claim or prosecute a claim. Okay, so keep that in mind. Okay, after the duty to defend, we get to the exclusions. Now, the exclusions are things over which we have no control, things that we're not going to insure against because there's really no way to do it responsibly. So what do they include? So stuff that you can or can't do with the land under the basic policy, we don't cover that. We don't cover the characteristics of the property. We insure title to it. There's a difference. I used to have this argument all the time with the opposing counsel. And I'll tell you some of those stories too. So, for example, exclusion 1 on the standard owner's policy says, we won't pay loss or damage costs or attorney's fees that arise by reason of any law, ordinance, permit, or governmental regulation, including those relating to building and zoning, restricting, regulating, prohibiting, or relating to the occupancy or use or subdivision of the land or environmental protection, unless there is a notice of same recorded in the public records. Public records, defined term. Okay. You know why we do that? That's because there's so many laws, they change all the time, and the government gets it wrong. So one of my early claims was it was actually the plaintiff's counsel was a retired judge, and the claim came in because the county had approved a subdivision on a beautiful piece of land. High-end homes were going to be built up on top of a plateau over the river. Was spectacular. The problem was after like 4 homes had been built and the insured had built his garage because became the staging area for the mansion. The county issues a cease and desist order, says, oops, we messed up. We did not have the authority to approve this subdivision and no more building can take place. Well, okay, but that's not covered because we don't have the ability to control these folks. Another case, the county issued a blanket statement that like 6 or 7 subdivisions they had approved were illegal. And that was because they've discovered many years later that the surveyor who on the project, who had certified all the drawings, wasn't licensed. He wasn't a licensed surveyor. And that was a problem. The bigger problem was that all the homes have already been built and people were already living in them. So what are you going to do about that? Nothing. Okay, moving on to and by the way, there's a bunch of other exclusions in there that we don't need to get to right now, but they're there. You should read them, should know what they are. And we'll talk about some of them as we go through claims. Okay, next are the conditions of the policy. These tell us how the relationship between the insured and the insurer is to be governed. In essence, the obligations of the insured and the insurer. They also give us the definitions for the defined terms. Anytime you see a capitalized word in the middle of a sentence, you know that is a defined term. I mention that again because it's important to know. Okay, there's 16 defined terms in the ALTA owner's policy. Okay, some of them are very lengthy, like who is the insured? It's important that you know that. Who is the insured under the policy? There's a lot of folks that could be insured. Okay, we talked about Schedule A. Now, Schedule B contains the general, aka standard exceptions, such as parties in possession, survey matters, mechanics liens, as well as the special exceptions. These are things that we discover in the title search that affect title and are specific to the land for which we are insuring. So think of title insurance as, I'm not going to insure you today for an accident that happened yesterday. Unless, of course, I don't find that that accident took place and you don't know about it. And so now I have insured you against it. Okay, well, that's it for today, folks. I probably went way too long, but I want you to remember, don't just close it, own it. That's your closing advantage.